Yo, make sure you got your paperwork straight. I got Mickey the Truth.
Let's get one thing clear. This your girl, Mickey Truth. South Carolina, 803 to be exact. What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So what's up, Truth Team? I'm back for the second time today, okay? I was supposed to go live like an hour ago. I told y'all earlier I was tired. I got to trying to make a video, and I was like, you know what? I can't even make no video at this moment. So I decided just to come live because we kind of ended the live earlier with me a little confused on what type of motion then Brian Steele hand to the judge and to the prosecution, okay? So, but before we get into all that, because y'all already know this is a content live, okay? So we're going to definitely be getting into a lot of business. So y'all already know, let's get into the disclaimers. Y'all already know all information contained on this live is for entertainment, heavy on a mother effing entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusion that you draw is on you and your mama, not nobody on this channel, this panel, or in this chat. And another disclaimer for those who have not read the description to my channel, I am not a lawyer. Nothing I say should be used as legal advice because it's not legal advice, okay? If you do need legal advice, however, you can go talk to an actual licensed lawyer or attorney of your choosing, all right? And like the disclaimer says in the video, that you can actually see the consequences of anything that you try to run with from the channel is definitely on you, all right? So with that being said, hey, just sit back, enjoy my opinion based off my free thoughts of what I'm listening to, and y'all let me know what y'all think in the chat. Let's get started.
You can't handle the truth.
Hey, you can't handle the truth. Blue boredom. All right, so how we gonna start this thing off? We got paperwork to go over, all that. But I just found out that I found out a lot of tea in the last few minutes, okay? So I got wind. Shout out to my truth team that helped me out to try to stay on top of everything that be transpiring out here in these cases, okay? So I have been told that Miss Bumpus, the lawyer who Woody said she filed a motion in this case, right? Now, before coming on, I checked to see if it was available on Fulton County website. It wasn't. Then I got sent the link to Infamous Sylvia. Shout out to Infamous Sylvia. Y'all make sure y'all go subscribe to her channel. She actually had Miss Bumpus pull up to her live. Now, her live is still going on, but I think I found the time mark where she started talking. So we're going to tap into that, okay, to see exactly what she got going on. All right. So again, y'all make sure y'all subscribe to Infamous Sylvia. She be front row and center down there in Fulton County. And let's see what they get talked about.
Hey, y'all.
Hey, there you go. Well, you have the floor, Kayla.
I don't have nothing to say, but hey.
So you know, I read the motion that your attorney put in for you. So can you say anything to us?
No, he's already mad at me. He's telling me to get off.
Yeah, you see, it is her. We are not going to have to incriminate herself, so we're just gonna put everybody else back up here. All
right. Well, bam. That's the type of interviews I like. Okay, let you know straight up front. They ain't got nothing for you. All right, so give me 1 second, because what I had, I think, yeah, this is Brian Steele. I got Brian Steele motion. Why? Well, let's go a little bit further back and see what her motion is. Oh, it's under Khalif. Okay, hold on, y'all. Let's see something. Give me a minute. So if you didn't know, it's multiple defendants on this case. And everything isn't filed under the same defendant. So I always go look under Young Thug. But if you notice, this one is not under Young Thug. Let me see if it's under there. That's why the team couldn't find it. We've been looking under the wrong defendant. Let me see, is it under here? I think this is it. Wow. Fulton County stressing me out. Like, why are y'all doing me like this? All right, hold on, y'all. I wonder, is that it, though? Hold on, let me see. Let me log on through my phone. Motion to watch it. That's what I was looking at. All right. I wanted to get my own copy of it, but I'm kind of at the point where shit, I could technically just go off of what she got, but I'm just gonna get my own copy. All right, y'all bear with me as I get into this system. I don't know why it's not letting me do that. Shoot, on my doggone laptop. And it's only that one. I tell y'all, sometimes I be like, man, they got it out for me. But it's no reason why they should have it out for me in Atlanta. So that's what I'm like, it can't be that. It got to just be, maybe my laptop's just old. I don't know. But I couldn't buy the thing off my laptop yesterday. So now I can't do it today. Code. No, it's doing it on my phone too. All right, I guess we're just gonna use her because this error. Do anybody know what this error means? Because this error came up on my computer and on my freaking phone. So, all right. Shout out to Infamous Sylvia. We're gonna use hers. I think it's only 2 pages, so it's not a lot, and then we'll get into what Brian Steele filed on the motion. Okay. So let's just blow this up because I'm gonna try to read it. Shit, I can't read that shit. Hold up. With glasses. I can't read it. Hold on. Let me see. Now I see what people be saying when I be posting my stuff. And they be like, we can't see it because I damn sure can't see it. Not clear. Let's see. Let me blow it. Ooh, that's too big. All right, so motion to quash order to show cause and motion to recruit this court. On Friday, June 7, 2024, during the trial, the state immuned Kenneth Copeland and called him in a witness. Okay, that's exactly what it says. Copeland refused to testify. The court placed Copeland in custody and for the weekend for all right, hold on. Refusal and adjourn until Monday. At this point, Copeland was still sworn in as a witness and had not been dismissed. On Monday, I just hit my toe. On Monday, June 10th at 8:30 a.m., Copeland and his lawyer, attorney Caleb Bumpus, were escorted to this court's chamber and conducted an ex parte meeting regarding whether Copeland would testify. Those present for the substantive portion, I can't pronounce that shit, of, and then let's go to the next part. Of this ex parte meeting were Chief Judge Glanville, Copeland, Attorney Bumpus, Assistant District Attorney Adrian Love, Simone Hilton, members of the court security staff and deputies, 2 investigators from the district attorney office, and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke the Fifth Amendment privilege on the stand. A conversation among the parties regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Copeland decided that he would testify. Copeland added that his testimony would be a lie. The meeting ended and this portion went to the courtroom. Oh, the parties went to the courtroom. This ex parte meeting was not placed under seal. There was no protective order that directed the disclosure of those ex parte communication was prohibited. No attorney-client privilege existed clearly, as 2 prosecutors, investigator, a judge, a court reporter, and various court staff were all present. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of records in this case, who also were fellow officers of the court. If there was any privilege, such as attorney-client or work product, the privilege would be destroyed with all other parties present, particularly the court reporter. All right. Y'all bear with my hooked on phonics reading just now. Okay. Shout out to infamous Sylvia. Okay, so that is from Woody's lawyer, well, ex-lawyer. What's up, Haitian? Caleb Bumpus. All right. So that was a bombshell. That was actually filed Friday. It's just coming to win because, again, I didn't see it because I'm always checking under Young Thug name and not under Khalif Adams. So, and if you're wondering why Khalif Adams, well, he's the first name on the indictment. So, bam. So that's one that happened. Next, we have, again, remember at the end of trial, I was like, what did they just say? You know, and nobody really knew what they had just said. Well, this is what was presented to the judge and what was presented to the prosecution, okay, by Brian Steele. Is motion to disqualify/recuse Judge Glanville from all further dealings in above referenced case, and motion for mistrial, which was guarded by the improper conduct committed in concert by the court and prosecution. If I had sound effects, this would be the moment I would put the sound effects in, for real, okay? Because now we are getting into factual. So, first and foremost, before we get into this, like any other time we get into paperwork, what's up, Essence? Y'all know I ain't gonna go verbatim, but we're gonna get into it's 27 pages. We're gonna get into most of it, okay? Now, I'm gonna try to keep this kind of not too long because I do want to kind of condense it for a video, and I'm tired, and we back at it tomorrow. And if this is any sign of what we're gonna have going on tomorrow, I need to be rested. Okay, so let's get into it now. We gonna skip that part. So let's start off with this. We gonna just start at 1. Undersigned counsel represents Mr. Jeffrey Williams in above referenced case. The jury trial of multiple accused persons commenced January 4th, 2023, before a Fulton County Superior Court Judge Glanville. The trial is expected to last at least through the end of the 2024 calendar year. On Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with prosecutors, engaged in an unlawful, improper, ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, from whom an order of use immunity had been issued on Friday, June 7, 2024. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in this case. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred. Star Chamber is crazy. Okay. Mr. Copeland had previously been called to testify on Friday, June 7, 2024, asserted the Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use immunity. Judge Glanville and the prosecutors essentially admitted by silence and by the statements in open court that an ex parte meeting occurred on the morning of June 10, 2024, only after undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. And that's true. We watched that in real time. Okay. So, at the earliest opportunity on the afternoon of June 10, 2024, the court was informed, based upon information and belief, that the ex parte meeting with the sworn witness, Kenneth Copeland, and the prosecution occurred earlier that day. That the witness had made factual admissions and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland could be held in custody on the contempt. The court denied undersigned counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based upon this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, a fair trial, a fair tribunal or whatever, ethical prosecutors, and the right to the present at every the right to be present for every critical stage of the proceedings under the Georgia Constitution. That right there would make you say, oh yeah, he's about to go free. He was like, what the fuck? All that was violated. Let me see. A transcript of okay. Okay, that's the trial. Okay, what's next? So they're about to break down the ex parte info when it comes to Georgia, right? So it says blase generally prohibit ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impeding proceeding. I believe, right, that if I'm not mistaken, I think Steele said that, read that, or I could be tripping. I heard so many lawyers, so I kind of think that, yeah, I'm pretty sure the jury will be sent home tomorrow. If they're not sent home tonight, I'm not sure if they have to come in and then be sent home, but yeah. All right, we're not gonna get into all the case law. All right, so let's go to 5. The court violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined a prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors as objectively demonstrated on June 10, 2024, as well as throughout the pendency of this case. And I'm gonna tell y'all, I said it today, right? The way he did that ruling on the Woody's interviews with the police proved it all. Because like at first he made a statement that made sense. He was gonna go against it, and all of a sudden he just said, "Yeah, I'm gonna allow them in." So yeah, if it wasn't clear to me before, after that it was definitely clear. Okay, 6. The trial court rejected undersigned counsel's substantive request for information about an unlawful ex parte meeting, and the court denied undersigned counsel motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur, and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County District Attorney Office, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutors still remain mute. Hey, I just want to say, remember, Love was the main one voicing, oh, it was a civil matter. It was a civil matter. It was a civil matter. Hold on, y'all. So that's something. All right. So undersigned counsel declined to join the antics and ignoring rules and ethical provisions, and declined to provide information requested by the court, relying on State Bar Rule of Professional Conduct 1.6, which states, and remember, he read that, and remember the judge said you can't hide behind 1.6, and even the prosecutor's office was saying 1.6 didn't matter either. Just saying. I remember that. I'm not about to get into all that. He technically read that in open court. All right, 9. The court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way that undersigned counsel obtained that information was somehow unlawful, and baselessly accused undersigned counsel on the record of potentially acquiring information through eavesdropping. In response to the accusation and the admissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent, and declined to provide the source of information which have been proffered. The court is so biased against undersigned counsel and or Mr. Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and others. Listen, this shit, I don't even know if you could make this up for a movie. Like, they technically played into the hand that's about the belt to ass down, for real. So this seems like it's about to get real messy. Real messy. All right. 10. The court issued a written order of contempt and incarceration for Brian Steele, imposing a maximum sentence of incarceration for 20 days. And they have an exhibit attached to this that we'll go over. The Supreme Court of Georgia has granted a writ to address the appeal. Remember, that's why he didn't have to turn himself in on Friday. 12. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceeding where the announcement of punishment is delayed and where these some big ass words for me tonight. Okay, I'm gonna skip it. Y'all see it. Conduct was directed towards the judge, or where the judge reacted to what the. I'm about to break this word down. What? Nah. What is it? It seems like I should be able to say it. Contumacious, maybe. What y'all think? Y'all think that's what it says? I kind of want to know what it means. Hold on. Google it. I want to know what it means. Because I don't even know what it means. Let me see. Hey, you ain't never too old to learn. Stubbornly and willfully disobedient to. See, I done learned a new word to add to my vocabulary. Okay. All right. Where was I? The judge may give the attorney. Okay, we already went up there. Okay. So it goes down further to say this created conflict of interest for the court because its own unethical conduct is questioned. And at the heart of the issue, the court then compounded its abuse of power by presiding over the very contempt hearing when its own rules violations prompted the controversy. And what was her name? Ashley Merchant definitely put that on record. And also, I think the judge was so confused with what contempt he had going on that it went over his head. All right. So then it goes to say the court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has a right to adequate notice and to be heard, to call witnesses at the hearing, and to be represented by counsel for the entirety of the contempt proceedings. And Mr. Williams had a right to learn of all facts and circumstances of this critical stage of the proceeding that occurred in his absence, ex parte. Jeez. Yeah, definitely corrupt. Okay. If that don't train corrupt, I don't know what does. Okay. Oh, yeah, the judge is out of here. Hell, at this point, I don't even see how the DA can bounce back from this and still try this case. Like, for real, I just don't see how that's going to happen. All right, where was I? All right, 14. The court abused, and they got the best wording for this stuff, okay? Abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process. Hey, this is crazy. Do y'all see the last sentence? Like, I was trying to read ahead and I was like, damn, this last sentence says, this court refusal to acknowledge these rights and protections has created an unfair, okay, based upon bias against Mr. Williams and or his counsel and favoritism to the prosecutors. I agree, because I tell y'all today, I haven't watched the whole trial, but today was clear it was favoritism, because there's no way he should have allowed them videos in today. Just like the whole video, it took a whole, 7 hours almost of watching that damn video. All right, next, motion to disqualify recused Judge Glanville is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse should be no later than 5 days after the, is that affiant or whatever, first learn of the grounds for disqualification. One, two, three. Oh shit. They're right. Come on, say damn, it seems like it's been over 5 days. But hold on. I wonder if it's 5 business days, because technically 1, 2, 3, 4, 5. Saturday would have been 5 days. Must be 5 business days. Okay. I told you this was gonna be a mistrial last year. Hey, you look. You must know something about down there, because this here is crazy. Now, I'm going to be honest. I said to y'all, I didn't call it mistrial for sure. I just said I don't think it was going to make it to the jury for some reason. And it seemed like it might not make it to the jury at all, because these are like big allegations. Like big allegations. And at this point, with Bumpy is on record now saying that this meeting did take place and all that, this is a problem for the prosecutors and the judge. And I know the judge like, damn. Oh, boom. They just said it. Excluding Saturdays and Sundays. Okay. Okay, so I think they're about okay, I guess, yeah, let's read this. So 16, the record also reveals numerous instances during trial where when a judge behavior appears to have been biased against Mr. Williams' counsel and partial in favor of the state. Then it gives that. Okay. All right, so we're gonna move past. I thought it was gonna say exactly when. Let's go down a little bit. All right, let's start. So it said the judge's conduct, as discussed above in hearing, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial towards the prosecution. Higher courts need not to decide whether such bias and impartiality actually existed because the judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, and that it has definitely been questioned, okay? Including instances where the judge's behavior could indicate that he has a personal bias, and y'all know I can't say that word for real, concerning a party or his party's lawyer. As explained, the trial judge in this case participated in ex parte communication with the prosecutor in which he assisted the state to influence a witness to testify against Mr. Williams. These actions certainly raise reasonable questions concerning the judge's partiality and bias. Because the trial judge's impartiality is reasonably questionable, it is error to deny Mr. Williams' motion for recusal. Our highest court has set forth at least 3 circumstances in which recusal of a court is necessary on the grounds of mere appearance of bias, even in the absence of evidence of actual bias. Mr. Williams does not waive that actual bias has been objectively shown throughout the trial as well as on June 10th, 2024, but for simplicity, the appearance of bias is also made. 2 of these circumstances arise in the case at bar. Then it says the third circumstance in which recusal is required on the ground of mere appearance of bias. So it's a let's see that. Controversy. This is definitely controversy. Second, due process when the judge takes a role in because he attended the meeting. Okay. All right, let's go to 23. In the case at bar, the court met ex parte with prosecutors and sworn witness Copeland and never attended to reveal that ex parte meeting occurred to Mr. Williams and on his counsel or to anyone for that matter. The court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting, including the fact that this meeting occurred. The court and the prosecutor should not be working together, but they are teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protection of due process of law. The court is biased against the accused and his counsel. Yeah, that's that. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. Tell you, wordplay is crazy. This court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, bias, partial, potential senator, and thus must be removed for this case in tutu inster. That's Hurry up. Yeah. All right, let's get to the affidavits. Cause shout away, I'm over here yarning. Okay, let's see here. Let's go to 33. Judge Glanville, lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demands all ex parte meetings to be disclosed in order to properly reveal the full the full extent of the violation of law and ethics. Again, lawyers for the state, Love and Hilton, and Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial voted by the conduct with these parties and judges. Hold on. All right, that's something. Sign field delivered. Exhibit A. Oh, yeah. I was tripping about doing this tonight. Jesus. Okay. We basically know what happened with that. Let's go over 4. On Monday, June 10th, 2024, undersigned counsel asked to have a transcript or whatever conversation were. Where am I? Okay. This court has obstructed Mr. Williams and below lawyers from having an exact image of what was said. This obstruction alone shows that the court is biased, that there is absolutely no privilege in commitment. Hold on, y'all. Shit. All right, y'all. This is what we about to do. I'm gonna drop a video tomorrow. I'm tired. Because once I got going, I realized I'm sleepy. These words starting to look blurred. Everything's starting to look crisscross. I'm about to get off live, y'all. All right. So for the most part, I wanted to go over this since it was up in the air what it was that Brian Steele handed the court today. But I will drop a video condensing this probably tomorrow after court. Your girl is about to go to sleep, okay? I appreciate y'all. Thank y'all for tuning in. Sorry it was so short, but yeah, I can't hang, y'all. I'm over here. My eyes, everything is crossed. So I'm out. I'll see y'all tomorrow.
Remember me wearing a frown. Now it's the other way around. They mad because I made it out.
I took the hard way. I ain't asking a nigga for nothing. I threw the hard way.